All right, we are now streaming live on YouTube. This is the preliminary hearing for Mr. Andre Gaines. Are you Mr. Andre Gaines? All right, he has nodded, indicating that he is Andre Gaines. We're about to start your preliminary hearing. All right, this is the state of Georgia versus Andre Gaines, warrant number 2025 WA 06886, possession of marijuana less than an ounce. 2025 WA 06887, theft by receiving stolen property. 2025 WA 06888, possession of a firearm by a convicted felon. Representing the state is ADA Thomas. Representing the defendant is Attorney Javard Rogers. Your witness, Attorney ADA Thomas.
Thank you, Your Honor. Officer, can I get you to raise your right hand? Do you solemnly swear and affirm that the evidence you should give before the court shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you for being down. Station.
I couldn't hear you. What'd you say?
State your name for the record.
Officer Freeman, Clayton County Police Department.
And were you so employed on or about September the 9th of 2025?
Yes.
And on that date, did you have occasion to investigate an incident that occurred at or around Terra Boulevard at its intersection with McDonough Road?
Yes.
And is that within the confines of Clayton County?
Yes.
And did that investigation involve an Andre Gaines?
Yes.
Can you please advise the court as to what happened on that date at that location involving yourself and Mr. Gaines?
I conducted a traffic stop on a vehicle. He was the passenger inside the car as well.
Okay, before we get too far, what was the nature of the traffic stop?
Oh, the registration was expired on the vehicle.
Okay. And you say that Mr. Gaines was a passenger in that vehicle?
He was.
Okay, now what happened? How did he get involved with the stop?
He got involved when we had probable cause to search the vehicle due to the driver advising that there is marijuana inside the vehicle. So once we pulled him out of the car as well as we were searching, we located a firearm inside the car, and that's when we used GCIC and we determined that GCIC showed that the firearm was stolen out of Spalding County.
And where did you find the weapon?
My partner actually found the weapon and notified me, and that's when I went and you ran the serial number, and that's when I found out the firearm was stolen.
Okay, but where did you find it? Where was it found inside the vehicle? Well, where was it found?
I think he told me it was under the driver's seat.
And Mr. Gaines was.
I can hear you. Your mic went out.
Mr. Gaines is the passenger?
Yes.
Did the driver or did anyone in the vehicle claim the weapon?
Nobody claimed the weapon at all.
And the weapon was the only stolen object in the car?
Yes.
Exactly where was the marijuana found?
I don't remember exactly where it was found.
Do you need to refer to your report?
Yeah, give me one moment.
You know, may the officer be allowed to refresh his recollection?
Yes. Mhm.
Also, let me know when you're ready.
Give me one moment. Yeah, yes, the marijuana was found in the cup holder of the vehicle.
Do you know where that cup holder was located?
The cup holder is in the center of the vehicle.
Did this gentleman have access to that cup holder?
Yes.
Do you know if anyone claimed ownership of the marijuana?
No. Nobody
Did
claimed ownership. The driver just informed that it was in the car, but neither one of them claimed ownership of it.
but the driver told you that it was in the car?
Yes.
Was anyone else in the car other than the defendant and the driver?
No.
Was this defendant the only person arrested, or were both people arrested?
Both individuals was arrested.
And no one claimed ownership of the weapon.
No.
Now you have Mr. Gaines charged with possession by a firearm by a convicted felon. How were you able to? What was the basis of that charge?
So once I finally was able to identify Mr. Gaines, it popped up showing that he has he's on probation. So I
Yes.
contacted his probation officer, and he informed me that yes, he is a convicted felon, and that he is not supposed to be around or possess any firearms.
Now you said that it popped up. What do you mean it popped up? I mean, did
So
it
so
like a mushroom,
when
or what happened?
so during GCIC entries, when we run a person by their name and date of birth, it will let us know if they are on probation. So it gives us their probation officer and contact them if they have any contact with law enforcement. So that way they can be informed of what's going on. And so I contacted his probation officer, and that's when he informed me that he is a convicted felon.
And when you reference this, did it show you a picture? The officer just able to confirm based on the physical description you gave.
I'm sorry, I couldn't hear you. Your mic went out again.
When you talked to his probation officer, was he able to like review a picture to confirm the ID, or did he just do it by physical description?
I gave the probation officer the name, and that's when he said, "Oh yeah, he knows who he is. That's his person." Because he also has a warrant out of Spalding County as well at that time.
So you called the Spalding County probation officer?
Yes.
Okay. Now, are you able to see who's in court today?
Yes.
The person that you had this encounter with on the incident date we previously discussed, do you see them in court with us this morning?
Yes.
Can you describe him by physical appearance or article of clothing?
You got on an orange jumpsuit with a white T-shirt up under, black male, mini dreads. It seems.
And the conditions of his probation specifically state he cannot be weapons?
When I talked with his probation officer, he informed me that he cannot be around or possess any firearms.
Judge, I'm objecting to relevance just in case we won't spend any more time.
Oh no, I'm moving on. In fact, that's it.
All right.
That's all I have this offset this time. You're on reserve right for redirect.
All right, Cross.
Thank you. Officer Freeman, just a few questions. Just want to make sure I'm clear. Mr. Gaines, he's not the driver, correct?
That's correct. He was not the driver.
Okay. And the gun you said was found under the driver's seat, correct?
That's affirmative. Yes.
And well, let me ask, I know you said the driver told you that there was weed in the vehicle. Do you recall whether or not the driver actually said they had been smoking weed?
But she informed that there was marijuana inside the vehicle.
No further questions.
All righty. Any redirect?
You don't mute any comments.
No, Your Honor, but thank you, Attorney Rogers.
All right, closing argument.
You're on our reserve.
All right. Go ahead, Attorney Rogers.
Thank you. Judge, I guess I just, it's pretty from my perspective, is a pretty open and shut case that should be dismissed for lack of probable cause. I'll start with I guess, what's most foundational to the whole case, the concept of possession. There's been no basis to establish that Mr. Gaines is in possession of anything. Number one, he's not the driver. There's no testimony that he's the driver or the owner of this vehicle. So there's no basis to attach any sort of presumption under the law against Mr. Gaines. He's just a passenger. Get, I guess, a little more specific about it, to quote a little case law in the situation, there's a couple of things I want to make sure is at the forefront. Number one, to quote, and I'm trying to pick which one, but there's a couple of different cases. O'Neal v. State, Georgia Supreme Court case, 285, Georgia 125, 2009 case, says it is well established that a finding of constructive possession must be based upon some connection between the defendant and the contraband other than mere spatial proximity. That's all we have here, Judge, is that he's a passenger in a vehicle. Nobody saying that they pulled anything off of Mr. Gaines' person, saw Mr. Gaines handle anything. So they actual possession, they have no avenue to get there. Constructive possession is all that's left for them. To speak to that, I would refer to Mitchell v. State, which is 268, Georgia 592, another Georgia Supreme Court case, which says that there is no presumption of possession because Mitchell, in this case, the defendant Mitchell, did not own or control the car. He was a mere passenger. And I'm still reading the quote from the case. And the fact that the cocaine was found on the passenger side of the car is of no consequence. A finding of constructive possession of contraband cannot rest upon mere spatial proximity to the contraband, especially where, as here, the contraband is hidden. And I'm using that for two parts of this. For one, the gun found under the driver's seat, that's hidden as far as from Mr. Gaines' standpoint. It's not in sight or anything like that. So we have a gun found under the driver's seat of a vehicle that Mr. Gaines is not driving. There's no basis to put him in possession of this firearm. So I would ask that, like I said, there's no basis to say that he's in possession of anything in this vehicle, because I want to be clear, even though the court stresses about it being hidden, it still counts even if it's not hidden. It could be laying out in the open. You still have to have some sort of connection to it beyond mere spatial proximity to the contraband. At this point, there's nothing connecting Mr. Gaines to anything. The driver's the only one that is testified to have been commenting on the possession, or excuse me, the presence of marijuana and guns found the driver's seat. So there's no basis to say that Mr. Gaines is in possession of anything. And I would also mention there's another case, Wofford, where they talk about another similar situation. Give me 1 second. Yes, an appellate case from 2003, 262, Georgia App 291. In this one, the Court of Appeals found it insufficient to establish possession. Judge, you still there?
Judge Case Johnson.
Yeah.
Judge, can you hear me?
Yes.
Okay, we lost
I'm
the
sorry.
No.
It cut out for a
Yeah.
minute, Judge.
What I was saying is about Wofford, the appellate court there says in the instant case, the only evidence connecting Wofford to the gun is the fact that it was found hidden under the seat where he had been sitting. We don't even have that here, Judge. And the court in Wofford found that, again, this is mere spatial proximity, and it was insufficient to support a finding that he possessed a gun. So again, Judge, there's no basis to say that Mr. Gaines is in possession of this firearm based on the testimony. Additionally, and I would say that would cover all of the charges. I want to be very clear. I think that argument applies as it relates to the marijuana and both of the gun-related charges, or I should say the theft by receiving and the possession by a firearm. Additionally, I would also point out, just speaking to the theft by receiving part of it, there's been no testimony about any circumstances or anything that would say that Mr. Gaines or anyone would either did know or should have known that this gun was stolen. And I would just point to Sharp v. State, which is a Georgia Supreme Court case, 310 Georgia 254, where the court talks about although the state produced evidence that a gun had been stolen 10 months prior and that the defendant was in possession of it shortly after a shooting, the state offered no other no other evidence relevant to this count, that being theft by receiving. It says specifically there's no evidence from which a jury could infer that he knew or should have known that the gun was stolen. And then they note another case, Doughty v. State, where they also found it insufficient because evidence shed no light on defendant's knowledge of the handgun's provenance. So in other words, if there's no basis to say this man knows anything, number one, about the gun being there, not even in possession of it, there's no basis to say that he knew or should have known it was stolen. So for all those reasons, Judge, I'd ask that all of the charges be dismissed for lack of probable cause. Thank you.
All righty. Go ahead, ADA Thomas.
Judge, based on the officer's testimony, we know that he is just as likely to be the possessor of the marijuana in the cup holder as the driver of the vehicle. So state would contend that there is sufficient probable cause for that. Further, regarding the possession of a make sure I get it right, by a convicted felon, Your Honor. The key word here, which is why I asked the officer about it, was the conditions of his probation. And what he was advised is that the defendant cannot possess or be around weapons. In this case, it is acknowledged there was a weapon in the car. That weapon was found, I grant you, under the driver's seat, but nevertheless, this is a young man who is on probation that he was already wanted for, and was an additionally in violation of that probation by being in a vehicle where weapons were found. State would contend that there is sufficient probable cause in this case to bind this case over to the Superior Court.
Okay. So based upon the evidence presented, I do find this probable cause on the possession of marijuana. I do not find probable cause on the theft by receiving stolen property, as the gun was underneath the driver's seat, and possession of a firearm by a convicted felon. I do not find probable cause for that one. So no PC on theft by receiving and no PC on the possession of the firearm. So that's a total of 3 charges, but I do find sufficient probable cause on the possession of marijuana.
Yeah, and I believe that will go to state court.
Yes.
Officers, thank you so much. You're free to go. Yeah, and I'm ready on my next one. That would be Defendant Justin Willoughby, Officer Lieutenant Sturley. Lieutenant?
Yes, ma'am, I'm here.
Okay, you're up. And I believe that is Attorney Lewis's case.
Judge, that's my case. Can you hear me?
I can.
I am in an automobile, so with your permission, I would like to keep my camera off, but I am absolutely 100% in tune.
What's your name? If you can somebody can tell the deputy what inmate is next while I finish this paperwork.
Yes, ma'am. Justin Willoughby, deputy, can you hear me? Okay,
I can hear you, Miss Thomas.
thank you.
Ms. Thomas is still in this case?
Yes.
He just left. You saw that.
Well, he just said,
Maybe coming on with some other device.
no,
or something.
you're looking at it.
Okay.
Well, there he is.
Mhm. All right, so who we doing now?
Willoughby, Your Honor.
Willoughby. Mhm. Are you Mr. Willoughby? Justin Willoughby? Wait, Deputy, let him tell me the correct pronunciation of his name. It is Willoughby? Okay. All right, so the defendant has acknowledged that he is Mr. Justin Willoughby. We're about to start your preliminary hearing, sir. His camera is off. Okay. All right, this State of Georgia versus Justin Willoughby. This is warrant number 2025 WA 08716 obstruction. 2025 WA 08717 possession of marijuana less than an ounce. 2025 WA 08718 simple battery. 2025 WA 08719 possession of drug-related items. 2025 WA 08720 violation of Georgia controlled substance. Representing the state is ADA Thomas. Representing the defendant is Attorney Lewis. Your witness, ADA Thomas.
Thank you, Your Honor. Lieutenant, could you please raise your right hand? Do you solemnly swear and affirm that the evidence you should give before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down and state your name for the record.
Lieutenant Christian Sturley,
And how are you employed, Lieutenant?
Clayton County Sheriff's Office.
And were you so employed in that capacity on October the 12th of 2025?
Yes.
And did you have occasion to investigate an incident that occurred at or around 7434 Tower Boulevard, excuse me?
Yes.
And what's located there?
It's a gas station.
And what happened that well, first of all, did you have occasion to investigate an incident at Justin Willoughby?
Yes.
What brought your attention to Mr. Willoughby at that location?
Myself and another deputy initially saw another individual loitering outside the gas station for an extended amount of time. We had turned around, gone to the gas station. That other individual had walked inside the gas station and was sitting at the game machines. We walked inside. We identified that individual. Mr. Willoughby was sitting next to him. While standing behind him, I observed a marijuana cigarette in his ear, commonly referred to as a blunt. I made contact with Mr. Willoughby about that blunt in his ear. He just stopped and stared at me. He said, "I'm not doing anything wrong." He then grabbed the blunt out of his right ear and clenched it in his fist as I tried to take it away from him. I pulled out my handcuffs and attempted to handcuff him. He snatched back, pulled away from me. He was sitting on a stool in front of the game machine. A brief struggle was on. We ended up fighting him on the ground, where he continued to kick me and actively resist both myself and another deputy. He was then taken into custody, where about 17 grams of meth was found in his pocket, along with a glass pipe. We had to pretty much drag him to the car, to my patrol vehicle. Even when in handcuffs, he stood up. He tried to run away. Once we drug him to the car and got him in there, he also had multiple outstanding warrants out of Henry County for meth possession, as well as several other felonies.
Okay, so what happened to what you described as first of all, you described something as a blunt. What exactly is a blunt?
It's a marijuana cigarette. It's a rolling paper with marijuana inside of it.
Were you able to recover it?
Yes.
Were you able to confirm the contents as being marijuana?
Yes.
How were you able to do that?
By sight and smell.
Have you smelled or seen anything like this before?
Absolutely.
And when you observed this on previous occasions, what did it appear to be?
A marijuana cigarette.
But there was no field test on this particular object.
No.
Okay. And you also indicated that point to the after the struggle over the blunt, other items were found.
Correct.
And I believe you mentioned meth.
Yes, it was inside of a small plastic container, as well as a pipe with a crystal-like charged substance on it.
Now, when you say pipe, what are we talking about here? What did you see?
The glass pipe with a bubble, commonly referred to as a bubble.
And did it have any type of residue or anything in it?
Yes.
Were you able to make a determination of what that bubble was being used for?
Yeah, this is smoking meth.
And the other substances recovered, where did you
I'm sorry, you cut out.
You said there was another substance that with the pipe, a substance was recovered. Where did you recover that from? Was it on him? Where'd you get it?
It was in his right pocket.
Okay. And were you able to field test that?
I did.
And what was the outcome, or what was the result?
Tested positive for methamphetamine, which was then submitted to evidence and sent to the GBI for further testing.
Okay. Did Mr. Willoughby make any statements or comments to you about what happened?
Yeah, when I tried to get the blunt out of his ear, he kept telling me he wasn't doing anything wrong, and I was trying to get it away, and he continued to clench that blunt in his hand. Then he continued to provoke myself and another deputy, calling us obscene names, and that we were struggling trying to get him into custody and things of that nature.
And specifically, where did he strike you? Did he strike your partner? Did he hit both of y'all?
Both of us. I was trying to control his legs while he was on the ground to get him in cuffs, and he continued kicking me multiple times.
He was kicking, or he hit you?
He was kicking me.
Okay. And where did he strike you at?
In the face, in the chin, in the arms.
Did you require any type of medical treatment?
No.
Okay. Did he strike your partner?
Yes.
Same locations?
Yes.
Now, are you able to see everyone in court today?
I am.
And the person that you had this run-in with, do you see them in court with us?
I do.
Could you identify him by physical appearance or article of clothing?
White male, black beard, orange jumpsuit, white undershirt.
And everything that we've been talking about, the marijuana, the pipe, everything was found on his person?
Is correct.
And I believe that's all I have reserved right for redirect.
All right, Attorney Lewis.
Thank you, Judge. Can you hear me, Lieutenant?
I can.
Good. I know you can't see me, but that's just where we are. Say your last name for me.
It's Sterling.
Sterling. Okay. I was gonna mispronounce it. I'm sorry about that. All right. Lieutenant Sterling, you said commonly glass pipe with a bubble, commonly referred to as a bubble. I'm not commonly familiar with that. What do you mean when you say a bubble?
The end of the pipe is a circular device which you would use a lighter or other butane lighter or lighter to heat up the contents to smoke it. It turns narcotic into a fume to inhale.
I got it. So when it takes the place of a regular bowl, like on a cigar or something like that. Is that what you're saying? The bubble does? Okay, yeah. It doesn't do any of the other feature than that, right?
Right.
Okay, good. All right, hang on a second. Let me look at something else here. I heard you say this young man kicked you, and of some of the places that you said, one of the places you say he kicked you is in the face. Is he on the ground at that time?
Yes, he was.
Is your face down next to the ground, or is he doing a karate type kick?
My face was approximately 3 to 4 feet above him. I was down on one knee, trying to keep down while he was kicking.
Okay. And then I heard you say your partner got, or the other deputy got kicked. Similar fashion. Same situation. Face 3 or 4 feet above.
Well, the floor was wet when we were trying to take him in custody, which didn't help. So
Yeah.
everybody's kind of sliding around on the ground. So
Okay.
yeah.
Okay, now I get it. Now I get it. All right, hang on just another second for me. All right. I'm just gonna delve in this one little issue, but not for long. You say you saw him and another guy outside of the gas station.
No, I did not see him outside of the gas station.
Okay, you only saw him inside the gas station.
Right.
All right, and then when you go inside the gas station, you see without doing anything more this marijuana cigarette that you call a blunt.
Correct.
How do you distinguish that from a regular cigarette when you're looking at it?
Pretty easily. The smell was overwhelming smell of marijuana.
Mm-hmm.
Could see the marijuana residue in the end of it, which was hanging outside of his ear, and he had
Okay.
smoked one end of it.
He had smoked one end of it. All right. So you can see the residue of the marijuana hanging outside, and then he had smoked one ear. And then you say the strong smell of it. While the individual was there with you, I know you could smell it. But when the individual's not with you, meaning that he's moving out towards the car, you still smelling that weed in that area?
No, because it was on his
Okay.
person.
So you only got weed in one place. That's on his person. Is that right? All right. Let me just check this one more thing. All right. Has nothing to do with your observations thus far. Did you do any questioning of him at all, or you just took him in?
No, wasn't really necessary.
Yeah. All right, cool. Hang on a second for me. Judge, can I talk to the defendant for just a minute, please? Breakout room.
Yati, can you switch him over?
I'm sorry, Your Honor. Switch whom over?
Crail over to the defense jail, and the jail and I together.
Okay, one moment. So, Deputy, you're going to rejoin room 2, and I'm going to assign you to room 2.
Okay.
Avatar 11. Fort active speaker Avatar 11.
Judge, you with us?
Yes, sir.
Great. Jail is with us too?
Yes.
Great. No further questions.
Okay. All righty. Closing arguments or redirect, I'm sorry.
None.
All right, closing argument.
Um,
No, she's talking to me. She ain't talking to you. We
I
submit
have
on
to
the
make a
evidence, Judge.
decision.
You don't have to. We submit on the evidence, Judge.
Okay, all right. Based upon the evidence presented, I do find it sufficient probable cause to bind all the charges over to the Superior Court, Clayton County. That's the order of the court.
Judge, is this man on your Friday calendar, or does he have bond on all his charges?
On my word, it says.
I don't think he has bond on the drug charges, but I'll double check.
Okay, Judge, is he on the Miss Stanley Thomas? I guess is he on the
He
bond
has a
calendar?
bond on each charge. He does have a bond on every charge. Obstruction, 1,500. The possession of marijuana, 1,000. The simple battery, 2,500. Possession of drug-related items, 500. And then the possession of the meth, 2,500.
Okay, good. That's it. Thank you.
All right, and so do we need to keep him on the bond calendar for Friday?
Nope. No, ma'am.
Okay, all right.
Lieutenant, you're free to go. Thank you so much.
You.
All right, who do we have next?
Yana, can we do Nicholas Williams? That's Officer Tyson. Officer Tyson.
Now, Judge, with that happening, I'm gonna walk into Judge Morgan's courtroom and report, and then I'll log right back on.
Okay, all right.
All right, and I've only got the one left. So when I come back on, we'll just have that one.
Okay, sounds
I heard
good.
you say earlier how many you had. I'm like,
Yes.
Bye.
Well, Yana, if that's the
Okay.
case, if Mr. Lewis, do you have time to do one more?
I do.
Okay, Officer Tyson, if you don't mind, because that way we can be done with Mr. Lewis and move on. Officer Fender.
I'm here, Your Honor.
Well, I'm not your honor. I'm just a
My
DA.
apologies.
You are honorable. All right,
I try to be.
And what case is this one?
Lloyd.
It'll be
Lloyd?
Devontae Lloyd.
Okay. All right. Okay, I'm sure that's not Mr. Lloyd.
No, it isn't. Jay.
And I need to make the copies really quickly, so if you
Yes,
can just
ma'am.
get the defendant ready, and I'll be right back.
Yes, ma'am. Jail. Hi. Can we switch out defendants? Can I get Mr. Lloyd, Devontae Lloyd?
Can I get RH4? RH4.
I did what now?
I was calling on the radio for them to unlock the cell.
Oh, okay. Not my business. Thank you.
All right, I'm ready when you guys are.
Ready.
Ready, Yana.
Mhm. About to start the preliminary hearing of Mr. Devontae Lloyd. Are you Mr. Devontae Lloyd? All right, he has indicated that he is Mr. Devontae Lloyd. He is charged in warrant number 2025 CW 56148 criminal trespass, 2025 CW 56149 robbery. Representing the state is ADA Thomas, representing the defendant,
Speech off.
Attorney Craig Lewis, your witness, ADA Thomas.
Before ADA Thomas begins, Judge, let me identify to my client. I am here, sir. I've got my camera off. But are you able to see me? Okay, good deal. All right, go ahead, Judge.
All right, go ahead, ADA Thomas.
Officer, could you please raise your right hand?
Start my video. Button.
Do you solemnly swear and affirm that the evidence you should give before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Put your hand down, state your name for the record.
Officer Philip Fender, Clayton County Police Department.
And were you so employed on or about September the 22nd of 2025?
Yes, ma'am.
And did you have occasion to investigate an incident that occurred at 5930 Highway 85? I believe this is a apartment or number 302 Riverdale.
Yes, ma'am.
And is that within the confines of Clayton County?
Yes, ma'am, it is.
And what's located at that address?
It's the Holly Tree Townhomes. It's a kind of a halfway house of sorts between for people to get back on their feet.
And
A
is it
large
like-
complex of halfway houses, actually.
So it's a large complex, but it's being run as a halfway house?
It is a halfway house, a large complex of halfway houses there.
Multiple businesses or one owner?
Oh, one owner subleased out to different like charities and companies that would run halfway houses.
Okay, I got you. Now, did you have occasion to investigate an incident that occurred at this particular unit?
Yes, ma'am, I did.
And did it involve Devontae Antonio Lloyd? Or was
Yes,
it
ma'am, it did.
Okay. And what happened at that location on the previously provided date involving this gentleman?
So I responded to scene. I made contact with two gentlemen, two different residents in Unit 302, because they're different rooms all under 302. Two different people from there that had the same room. They both stated that Mr. Lloyd had come to their room and entered into their private bedroom without permission. Ranting.
Let me ask you a quick question, because I know you stated this is a complex being run as halfway houses. Do the participants of the halfway house share units?
Some of them do. So usually there's 2 beds per bedroom. That's the private area. There is a common space, which is bathroom, common area, kitchen, whatnot. In this case, my 2 victims in this case, Mr. Bird and Mr. Porter, are 2 roommates for the same bedroom. Mr. Lloyd, the defendant, lives in that same apartment but a different private bedroom. They share the same common area, but he has a different private bedroom.
So the occupants have private bedrooms, whether they're roommates or not. Each occupant has a private bedroom and shared common areas.
Correct.
Within the unit.
Correct.
Okay. So this gentleman, Mr. Lloyd, was not a roommate with the victims.
No, ma'am.
Okay. Now, what happened between the roommates and Mr. Lloyd?
What both roommates stated and their statements were concurring is that Mr. Lloyd had entered their private bedroom without permission, complaining that they had broken his phone. And what they were doing, what Mr. Lloyd was arguing about, is that because they had broken his phone, he wanted some kind of not retribution, but reimbursement per se. What both of them told me is that because Mr. Lloyd was being very aggressive with them, they told him to leave. He refused to leave, remained in their private bedroom without permission and refusing to leave. And then when he finally decided he was going to leave, he reached out, snatched both of the Mr. Bird and Mr. Porter's phones from their immediate vicinity, which was charging, connected to a charger, connected to a wall outlet, snatched both phones from their immediate vicinity, then fled the scene. And the reason what both victims gave to me for that is because Mr. Lloyd felt like because they had broken his phone, he deserved the right to take their phones. and Mr. Lloyd had fled the scene and was no longer on scene when I arrived.
Now, were the phones recovered?
No, ma'am. I was never able to recover the phones.
But both victims saw him take their phones.
Yes, ma'am. They were both in the bedroom at the time.
Did he have their permission to enter their private bedrooms?
No, ma'am.
Did they ask him to leave the room?
Yes, ma'am, they did.
And did he do so?
No, ma'am. He remained in there without permission.
Did Mr. Lloyd make any statements or comments to you about what happened between himself in his room and the occupants of the other room?
So I didn't find Mr. Lloyd till a couple days later when we got a separate call out there for him causing a disturbance. And when I arrested him, to my recollection, and I did refresh myself on my report before this court appointment, he did not make any spontaneous utterances regarding regarding the incident.
Were the victims able to see him to confirm his identification?
No, ma'am, I wasn't. They were not.
Now you say that he was identified on a subsequent date.
I located him on a subsequent date. I was able to identify him the day of the initial incident because I got in contact with the lady who runs the halfway house there. Yes, ma'am.
Okay. Did you get a physical description at that time?
Yes, ma'am.
And was that physical description used for anything since you didn't pick him up that day?
Yes, ma'am. I was able to use that physical description, compare it to the name and date of birth they provided with me, and I saw that the physical description matched.
And the person that you picked up a couple of days later, did they fit the description that the victims provided for you?
Absolutely.
And what about the person who was running that particular halfway house?
I wasn't able to make contact with her at the time, but when I actually did find Mr. Lloyd, I was able to make contact with a security guard for the Holly Tree Townhomes, and he was there for the original incident as well, and he was able to, yep, that's him, because he's the one who originally pointed me out to where Mr. Lloyd was. He had walked down the street towards the Chevron at the northwest corner of Highway 85 and Garner Walk Boulevard. I went out there, found Mr. Lloyd based off the security guard's description, then confirmed his identity before detaining him.
So the security guard was there on the initial date and was there when you came back on that subsequent date?
Yes, ma'am.
And he knows Mr. Lloyd.
My apologies. Sorry.
God bless you. He knows Mr. Lloyd. He's familiar with Mr. Lloyd.
Yes, ma'am.
And he was able to confirm that this is the same person that had the encounter on the previous day.
Yes, ma'am.
Now, we've been talking previous days just for purposes of clarification. The initial date was August the 22nd, I believe.
I don't remember the exact date. If you need me to, I can go back and look at the report. I don't remember the exact date.
I just want to be sure because he wasn't arrested on the initial date. You had to come back.
Correct.
So what was the initial date?
Initial date I was out there was August 22nd, leading in August 23rd, right around the midnight time frame.
And when did you actually detain him?
I detained him August 24th at about 11 p.m., 2300 hours. So what, almost 2 days after?
Okay. And the same security guard was on duty and was able to confirm him, the identity.
Yes, ma'am. Yes, ma'am.
Now, also, are you able to see everybody in court today?
If I scroll through all the tiles here, I am. Yes, ma'am.
Okay. The person that we've been talking about that you had you responded to an incident involving on the August the 22nd and that you detained on August the 24th. Do you see that person in court with us today?
Yes, ma'am, I do.
Can you describe him by physical appearance or article of clothing?
Yes, ma'am. He's a black male, short black hair. He's got a beard and a mustache. He's got the orange jumpsuit with a white t-shirt on underneath it.
Okay. And I believe that's all I have reserved right for the redirect in this matter.
All right. Go ahead, Attorney Lewis.
Thank you. It's Craig Lewis talking to you. Can you hear me, sir?
Yes, sir. Absolutely can.
Beautiful. Let me have your name and rank again.
Officer Philip Fender.
Philip. Okay, and then spell that last name for me.
Fender, Foxtrot, Echo November, Delta, Echo Romeo. Just like the
Got it.
fender of a car,
Thank you.
or the guitar.
Perfect. All right, Officer Fender. Hold on just a second. Let me look back over all of these notes I took with your testimony on Madam Prosecutor real quick. All right, Madam Prosecutor asked you about apartment 302. Is apartment 302 is this an apartment or is this a building?
So it's building 3. So again, like I've established, buildings here are weird. So you have individual buildings, and then you have different. I call them apartments because it's all the same common area. So it's 2 floors, and they just each have a common area and a kitchen. Common areas on the top floor, kitchen's on the bottom floor, and then you have individual bedrooms across the 2 stories. That whole 2 floors with the different bedrooms is 302.
Is 3 or 2 meaning the
302, 302.
Oh, I got it. So everything on the second floor is 302. I got it. Now, Lloyd is a resident at this building, correct?
Yes.
And is Lloyd a resident of the second floor also?
Unclear if it's the second floor or the first floor. They're all interconnected by an open stairwell with no controlled access.
Understood. Is there a lock on the door of Bird and the other individual?
If there is a lock, it's just on the door handle, like the turn little.
I got it.
Thing.
I got it. Nothing special requiring key, correct?
Not to my knowledge, no, sir. I could be incorrect, but not to my knowledge about the
I got
lock.
you. That's good enough. How does Bird say that Lloyd got into the room?
They said he entered the room. To my recollection, he didn't say how they entered the room.
Mm-hmm. So the door could have been wide open.
It could have been wide open, yes.
I got you. And the phones of Lloyd and Bird were both on the not Lloyd. Bird and the other individual were on the charger.
Porter. Yes, according to both victims, they are both charging on a wall outlet.
Okay, and is Lloyd's phone in the room?
My apologies. A little bit under the weather. To my recollection, no, Mr. Lloyd's phone was not in the room.
All right, so they have no earthly idea of what Lloyd's talking about. Is that right?
No clue.
All right. Fast forward me for a minute. You introduced that Lloyd was engaged in another disturbance on the subsequent date.
2 days later, on the night of the 24th, going into the 25th.
And that's not with Bird and Porter?
No.
All right. Now I've got this magic question, and here we go. You call this a halfway house, correct?
Mm-hmm.
In fact, sir. I think you said it was an entire complex of halfway houses.
Yes, sir. To my knowledge, it is.
Yeah, and it's got some other places in it that are rented out to different establishments, but this one right here is Holly Homes, right?
The whole section is called Holly Tree Townhouses.
Holly Tree Townhouses.
Or Holly Tree Townhomes. One of the either townhouse or townhomes.
So, officer, I'm familiar with halfway houses for people who are coming out of prisons. When you say halfway house, what does that mean?
It's a place for people that are coming out of prisons to stay, get themselves back on their feet. They work, save up a little bit of money when they have themselves established, and reincorporated back into society. They can go back. They can finally get their own apartment and be self-sufficient.
That sounds good. So that's my definition as well. So now, does this Holly Tree offer itself out to any other kind of individuals other than those that are coming out of prison?
I have no clue.
Okay. All right. Did you get a chance to walk into the room occupied by Bird and Porter?
I do not recall.
Okay. How did you arrive at the conclusion that Lloyd lived somewhere other than in the room by Bird and Porter? Was it only on their statement?
No, it was the other witnesses there, the security guard and the lady who rents it out, that
Oh.
both informed me that he lives in another room there. That's how I got his information in the first place.
I got it. Are they restricted from, meaning the residents in there, are they restricted from their movement? Meaning, I'm not going to talk about my earlier life, but if I found a friend in another room, am I told that I can't go in and be in that room with that friend?
I'm not clear on their rules to that extent.
Okay. All right. When you went back a few days later and you arrested Lloyd, did Lloyd have any phones in his possession?
So he had 2 phones in his possession, which
Mhm.
I immediately found suspicious.
Yeah. Don't do that. You're making me suspicious too. Were any of those phones belonging to Porter or Bird?
I returned to those 2 and showed them the phones. They weren't able to confirm that the phones are theirs, but they weren't, because obviously they're generic phones. We couldn't boot them up to determine. They couldn't confirm that they were their phones, but they couldn't deny it either. So it's
Understood.
undetermined at this point.
So Porter and Bird have so-called generic phones. They don't have one like through Verizon or AT&T or something like that.
By generic phones, I meant like they're smartphones, but they don't have any special markings on them. It's like there's no case. It's just a straight color phone.
Right.
We can't turn them on. There is no identifying mark on them for them to say specifically, "Oh, that's my phone."
I got you. So typically people have telephone numbers, except for my son. He only uses this for games. So is there telephone numbers that were called to see if they belong to either of these individuals?
We couldn't boot them up, so there's no way to tell.
So they were powered down.
Yes, sir.
Okay, I got it.
I believe one was booted up, but we weren't able to get anything past the lock screen because it had like some kind of security measure on it.
Okay. What were done with those phones when you were done with them?
I believe they were returned to Mr. Lloyd's possession because I wasn't able to confirm or prove that they were not his phones.
All right. And you did you have an opportunity to question Mr. Lloyd if one of those phones was the phone that he was accusing Porter and Bird of having?
If I would have questioned him, it would have been after I detained him. I can't remember if I read him Miranda or not.
Okay.
I don't recall any spontaneous utterances.
I got you. All right, thank you. Hold on just a second for me, please. Let me talk to my client for a minute, all right? Judge, can I speak with my client, please?
Yes, go ahead.
Thank you.
Active speaker, join radio.
I believe you can rejoin room 2.
Yeah, I'm going in there. Just have the jail join me.
Officer, you okay?
A little bit under the weather, ma'am. I got a pretty nice sized headache.
I'm so sorry. Hopefully we'll be through quickly and get you out.
Judge, I am back. Is my client back?
Yes.
All right, great. Officer, I got a few more questions for you. You with me?
Yes, sir.
All right, great. I'm told that there was a trash bag involved in this incident. Is that right?
There should have been a bag of his belongings that was in
Uh,
his residence. Yes, sir.
mm-hmm. Did you put all of the of his belongings into property?
Um, to my recollection, everything that was on Mr. Lloyd's person came with him to the jail. I don't believe there was any contraband that I found on him. As far as any of his belongings that were still in his private bedroom, I didn't touch those. I saw that they were there. They showed me that they were there in his room,
Mm-hmm.
but I didn't touch them just because they're his belongings. He lives there. I'm not going to mess with them.
I got you. Did you put anything into evidence at all?
I do not recall.
Okay.
If I need to refer to my report, I can, but I do not recall.
Yeah, I mean, you can if you want to, but it's not essential at this point in time. If you can't recall it, it's good enough. Did you have your body cam on?
Yes, sir. It should have been on for both
All right.
incidents.
For both incidents. Let's just deal with the one on the when you come back to arrest him in the end. That incident there, your body cam is on
Yes, sir.
at the time that you arrive. Did
Yes,
you
sir.
All right. Does it ever turn off from the point in time that you arrive to the point you close this case by arrest?
It shouldn't have. No.
Okay. Have you had a chance to review any of his content to know whether it recorded the event?
No, sir. I've
All
not
right.
had a chance to review it.
If one wanted to get a hold of this body cam, would they just simply refer to the first incident or the second incident number?
This one should be the body camera for the second incident should be under the same case number. I titled it by the same case number, but as a follow-up.
Okay. Understood. Understood. All right. Thank you, officer. I got no further questions at this time, Judge.
All righty. Any redirect?
No, Your Honor.
All right, closing arguments?
Let me see here, Judge. Just a second, please.
Your Honor, I'll reserve.
We're gonna submit based upon what I heard, Judge.
All right, so based upon the evidence presented, I do find that there is sufficient probable cause to bond both of these charges over to the Superior Court of Clayton County. That's the order of the court.
Thank you, Judge. And that's
Thank
going to conclude my business before you today.
Yes, have a great week. Well, I'll see
You as
you
well.
Wednesday.
Yes, ma'am, you will.
All
Lord's
right.
willing. All right.
Lord is willing.
Yes.
All right, who are we doing next?
Your Honor, I was gonna go back to Officer Tyson, but I think I'm gonna go ahead and get Officer Fender out because he's not looking too good. He hanging in there so far.
Okay, all right.
That would be Kofi Mensah, Mr. Rogers.
What's the last name? Oh,
Mensah.
Kofi.
Mensah, I believe.
Oh, yeah, Kofi. Okay.
Did the jail here? Now, do you see any other officers in the waiting room?
Mm.
We don't see any.
Okay, Your Honor, that will leave me with, including this 3 hearings left, and I will be requesting continuances on the remaining ones unless those officers pop up between now and then.
One officer just came in.
Okay, thank you, ma'am.
You're welcome.
Yeah, that's one. That's gonna be for Curtis Evans.
Yeah, can you find, the Lloyd's paperwork?
Yes, Your Honor.
I don't see it. Okay. All right, so Mr. Coffey, has 3 charges, is that correct?
Believe so, Your Honor. Let me double check it. That's what I have, Your Honor.
Okay, all righty. Are you Mr. Kofi Mensah? Are you Mr. Kofi Mensah? Yeah, okay, all right. He has, the defendant has indicated by nodding his head that he is, Mr. Kofi Mensah. We're about to start your preliminary hearing. The state of Georgia versus Kofi Mensah. And this is warrant number 2025 WA 04708, identity fraud. 2025 WA 04709, financial transaction card fraud. 2025 WA 04710, theft by taking. Representing the state is ADA Thomas. Representing the defendant is Attorney Javon Rogers. Your witness, ADA Thomas.
Thank you, Your Honor. Officer, could you please raise your right hand? Do you solemnly swear and affirm that the evidence you should give before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
You can put your hand down. State your name for the record, please.
Officer Philip Fender, Clayton County Police Department.
And were you so employed in that capacity on or about August the 1st of 2022? Excuse me,
Yeah.
2025.
2025, yes, ma'am.
And did you have occasion to investigate an incident that occurred at 50, I believe it's 5881 Eagles Feather Lane?
Yes, ma'am.
And did that investigation involve a Kofi Mensah?
Yes, ma'am, it did.
What was the nature of this investigation?
So we got called for a domestic disturbance at that location.
Is it a house, apartment? What is
it? It's a house.
Okay. And is that house located in the confines of Clayton County?
Yes, ma'am.
Any specific city?
Unincorporated, but by address it's Riverdale 30274.
Okay. And you say you responded to a domestic complaint of some sort?
Yes, ma'am. It was a domestic disturbance involving what we call a demented person.
Okay.
That's how it was dispatched over radio.
Okay. And did you have occasion to speak to the victim in this matter?
Yes, ma'am, I did. Both victims.
And what is the victim's relationship to this defendant?
So we have 2 victims here. We have the defendant's mother and then the defendant's sister.
And are they identified as such in the warrant?
They should be identified as victims. I don't remember if they're identified by relation.
Okay. And what did they advise as to what happened?
So the defendant's mother advised that the defendant had actually taken her bank card earlier that day and withdrawn $600 in cash from an ATM. He took the debit card without permission, and everything he did was off his own accord. And while the victim stated that the defendant returned some of that cash to her, $240 returned out of the $600 withdrawn, she was still missing $360. The victim also stated that the defendant had only been released from Grady Hospital from a 1013 involuntary hold that previous Monday.
And what day of the week do you recall this being?
This occurred on August 1st, if I can refer to my calendar, because I don't remember what day of the week that was. August 1st was a Friday, so 5 days prior, 4 or 5 days prior, I'd been released from Grady off of 1013.
And was he on any type of medication or anything, or did she advise?
I don't think she advised.
Okay. Now, did he take something from his sister, the other victim?
Yes, the other victim, the defendant's sister, also stated that he took some stuff from her. So the victim has a little girl, and the defendant took a pair of sneakers that belonged to the little girl. I believe they were a size 5 pink New Balance sneakers. Took those. Took his sister's wallet and purse containing her ID, and so wallet, shoes, her ID. Yeah, that's all he took. It was her little wallet, purse, handbag thing with her wallet and her ID, and then the pair of sneakers.
And these sneakers were taken from his own, I guess, child?
Not his child, his sister's child. So
his sister's child.
Yes. So the victim's little girl.
And she's a toddler.
Yes, ma'am. It's a size 5 child shoe.
Okay. And was he able to advise, or were they able to advise how the victim got the how the defendant got the victim's, and this is his mother, how did he get his mother's ATM number? Or
she didn't know. All she knew is he took her card and went out and used it. And the way she found out is she knows there's $600 missing from her bank account. So she looks, oh wow, $600 withdrawn from ATM. And to my understanding, she confronted the defendant about it, and that's when he returned some of the money to her.
Did he return the card to her?
I do not remember.
Okay. Can you consult with your report? Is that available?
Yes, ma'am.
Okay. Let me know when you're ready. You ready?
So I did not put in the report whether or not the card was returned to her, so I'm unclear of whether or not the card was actually returned.
Does your report also include the names of the victims?
It does.
Okay. What is the name of the victim mother whose bank card he took?
Miss, I'm probably going to pronounce this wrong for the record. So Miss Ajay Amponsa. First name is Ajay, Alpha Delta Juliet Echo India. Last name is Amponsa, Alpha Mike Papa Oscar November Sierra Alpha Hotel.
Okay. And what about the sister?
The sister, her, again, I'm probably going to pronounce this wrong, was Beatrice. Nope.
I think you got them backwards.
Yeah, sorry. The mom is the sister was Ajay Amponsa.
Okay.
The mom was Beatrice Ajay Mensa. So Beatrice Beatrice. Last name Ajay Adjei-Mensah.
Okay. So he took a bank card that you don't know if it was recovered, and he took the shoes of the child. Did he take anything else from his sister?
He took his sister's little handbag, purse look style thing, with her wallet, which also contained her ID card.
Did you have occasion to speak to the defendant about all of this?
I did.
And what did he advise, if anything, about the items?
All right. So about we're going to start with the debit card and the money taken. He advised that he was owed money, and so he took it upon himself to take his mother's debit card and reclaim said money. I asked him to show proof that he was owed that money, and at first he provided me with just a little slip of paper that just had some scribbled numbers on it. I couldn't understand what it meant because it was illegible, and when I further confronted him about it, he
Hold on, officer, you're cutting out a little bit. You say when he further advised you about it, and then it just kind of got swirling.
I apologize. I had to cough. I'm not feeling the best.
We almost there. Hang in there.
So he at first advised that he was owed money, and he showed me a piece of paper with what appeared to be numbers or letters written onto it. They're illegible. I couldn't understand what it meant. So I further confronted him about it, and then he admitted that he wasn't owed money. He just took the money for his own use.
So he admitted taking his mom's money.
Correct.
Did he advise as to what he did with her bank card?
He did not.
Okay. And what about with his sister? Why did he take her property?
So we'll start with the shoes. He took the sister's property because he said he wanted to wear the shoes. Granted, they're size 5 tennis shoes. He's a full-grown male. Obviously, those shoes didn't fit. He advised to me that he went to the Chevron at the northwest corner of Highway 85 and Garner Walk Boulevard and traded the shoes for a half-used carton of cigarettes. And then as far as the wallet goes, he stated that he wanted to buy a firearm. But he has an ID, but the one he provided me was, the paper one you get from the DMV before they send you your hard card one. He only had the paper one. He advised that he needed a hard card one to buy a firearm, so he took her handbag so he could use his sister's ID to go buy a firearm.
And that ID did have a woman's face on it, I would assume?
I was never able to recover it because he also gave it to an unknown man. What he advised me, is that he gave it to an unknown man at that same Chevron at the northwest corner of 85 and Garner Walk. And when he gave the purse to the unknown man, it still had the wallet and ID inside of it. To my knowledge, there's nothing else inside the wallet. It was just the ID, but nevertheless, all that was given to the unknown man.
Did he have either his mother or his sister's permission to take their property?
Absolutely not.
What about to take the child's shoes?
No, ma'am.
But he admitted doing both of those things, taking the items.
Yes, ma'am. He admitted taking everything.
Did he try to use the sister's ID?
Not to my knowledge. To my knowledge, there's no way for me to check that. That's beyond the scope of what I can do.
Okay. And did you get a value of the sneakers that were taken?
To my recollection, sneakers are $85.
And the money taken from the mother was around $600?
Around $600 cash. He had returned $240 cash to her, which I counted, on my body cam directly in front of her, which means there's $360 cash still outstanding, unknown what that was used on or where it is.
Plus the shoes and the sister's ID. Purse.
Correct. The purse and whatnot was valued at $15, the shoes $85, and $600 cash.
Okay. Yeah, I believe. Oh, you actually had two things. Were you able to preserve the conversations that you had with the victims anyway?
It should have been on body camera recording.
Okay, and what happened to that recording? Do you know?
To my knowledge, it was saved. It's on the database somewhere. The Polaris and Rocket iOS database.
And your conversation with the victim, not the victim, the defendants, was that captured the same way?
All in the same recording, yes, ma'am.
Were the victims able to advise whether or not they had any video of what would have happened or their interactions with the defendant?
No, ma'am. They didn't advise of any kind of video.
Okay. And you talked to him, the victims were able to confirm his identity to you.
Yes, ma'am. They were all there present at the scene.
He was still there when you got there.
Yes, ma'am.
Okay. And I believe that's all I have reserved right for. Well, one more. The person that you interacted with on that date, do you see him in court with us today?
Yes, ma'am, I do.
Can you identify him by physical appearance or article of clothing?
Yes, ma'am. He's a black male with short black hair, black mustache. Can't see if he has a beard or not because of the Clayton County jail tag, but he's got an orange jumpsuit on.
Okay. That's all I have reserved right for redirect.
All right. Go ahead, Attorney Rogers.
Officer Fender, if I'm understanding, I guess I want to make sure I'm clear on a couple of things, I guess. The first person you make contact with when you respond to the scene, who was that?
If I'm not mistaken, that was the defendant's sister.
Okay. And let me be
Miss Amponsa.
I'm sorry, go ahead.
I believe that was the defendant's sister, Miss Amponsa.
And then after that, you spoke to the mother?
The mother, Miss Ajay Mensa. Yes, ma'am. Yes, sir. Sorry.
Did you speak to anybody else other than the defendant and those two people?
Miss Amponsa had a 17-year-old daughter. If I interacted with her, it was right when I first got on scene, but she didn't really know much about what happened when I first entered the residence. That's why I made contact, or got to the residence. That's why I made contact with Miss Amponsa.
And I guess I'll jump to the part about the New Balances real quick. When you say a size 5, I guess I'm not, I don't have kids to know exactly what we're talking about. Are we talking about like toddler size sneakers or like school kid size sneakers?
Unclear if they're either kids sneakers or like a small woman's sneakers. All that Miss Amponsa says, her juvenile daughter did have a pair of size 5 New Balance sneakers.
And kind of going back, I think you said Mr. Mensa's mother, I believe you told you that he had just been released from Grady for regarding the 1013 earlier that week. Is that correct?
Yes, sir.
And just for purposes of making sure everybody's on the same page, when she says released from Grady on the 1013, what does that convey to you?
So that means he had been placed on an involuntary 72-hour hold at Grady Hospital. It's a Form 1013, involuntarily holding for a mental diagnosis by medical staff there. They released him, meaning that either A, they found they didn't need to hold him any longer, or they found they didn't need to hold him any longer for A, either they didn't find anything, or B, he was refusing treatment, or for some reason they didn't need to hold him any longer, so they released him after that 72-hour hold.
And to your knowledge, when they're telling you, I guess when the mom is telling you about that part, do you recall whether or not she told you he had been medicated or treated in any way during that time?
I do not recall if he had been medicated or treated. What she did advise me was that he suffers from schizophrenia, and they have had repeated attempts to get him mental help, but he refuses to accept it, and his behavior is continuously getting worse.
And as you understood it, were they being the family, were they seeking him to be, I guess, 1013 or mental or treated regarding the mental health, or were they seeking his arrest?
They were seeking help for it. I made the determination to make the arrest. I'm unclear whether or not they wish to 1013 or arrest.
Can you say that last part again? I just want to make sure I heard you correctly.
I'm unclear whether or not for this incident, the victims wished for a 1013 or an arrest. I do not believe they advised me of that.
You said, well, you said, I think you said, at least, correct me if I'm wrong, I think you said they were seeking help. Is that what you said?
They were seeking police help in the matter. How that help entailed, I don't know. They were seeking help, obviously, because they called us. Whether how they wanted that help or what they wanted that help to be, they didn't state.
And so if I understand, you had the conversation first, I believe, the relevant conversation as far as.
Attorney Rogers, let me interrupt you just for 1 second. I need to step
ma'am.
away for 30 seconds.
Officer, you okay?
Hanging in there.
Mhm.
I'm sorry, are you all waiting to go into a breakout room?
No, Judge just told us to hang on.
I stepped away as well. Thank you.
Yeah.
Okay, continue.
Also, I think I was about to ask about the order, just trying to make sure I was clear. I think you said you spoke with the sister, then the mother, and then Mr. Mensah himself. Is that the correct order?
Sister. Yes, sir. Sister, mother, then the defendant himself.
And so once you speak to him, if I'm understanding correctly. Well, let me ask, I guess, before you speak to Mr. Mensah, do you read him his Miranda rights or anything?
No, sorry, I didn't have to.
And just on clear on the conversation you're having with him is after everybody's made the allegations about what's happened. Is that correct?
Correct.
Going back to the mother, did she ever show you any sort of like transactions or anything, like receipts, any bank records or anything?
I believe she did. I would have to go find a photo on the attachment to the report. If there is one. I don't remember for certain.
And so then after, I guess when you're speaking with Mr. Mensah, if I understood you correctly, you said you have a conversation where he discusses using his sister's ID to purchase a gun. Is that correct?
Yes, sir. That was his intent.
The sister that's being referred to, is it the same one that you've already spoken to?
Yes, sir.
And so you've seen them both that day then, correct?
Yes, sir. All three were there at the residence.
Does Mr. Mensah, I guess for one, the way he looks now, is that about how he looked then as far as having a mustache or no?
I do not recall. I recognize the shape of the face.
And the sister, do you recall like what their heights were in relation to one another as far as who was taller or shorter or anything?
No, sir. They never stood next to each other, so I never get to check. I'm 6'4". At some point, everybody looks short.
And well, let me ask you this, I guess, as far as the two of them, do they look enough alike that, that if you saw an ID presented for the sister, you would think it was Mr. Mensah?
To my recollection, his sister has much lighter skin, and that's not something that could easily be confused.
Um, and last question, I just want to make sure I'm understanding. I think you said basically he traded away all of the things that were supposed to have been taken for, like I guess you called it a used pack of cigarettes.
What he informed me was a half used or partially opened carton of cigarettes.
No further questions.
Any redirect?
Not from the state, Your Honor.
Closing arguments, ADA Thomas.
I'll reserve.
All right, Attorney Rogers.
Judge, I guess if I have one moment, I just kind of want to do the charges. So, Judge, I guess I really think it's relatively apparent, I would hope, is that Mr. Mensah was not moving from a place of competence at this particular time. And, I think there's a couple of different things that will make that kind of hard to miss. One of them being the idea that, well, I shouldn't say the idea, we'll take it as a fact that his mother saying that he was just released that same week after having having some sort of serious mental health concerns raised enough that he was admitted to Grady for 1013. So I think that's our first clue. Secondly, we're talking about Mr. Mensah, his explanations, even regardless of whether or not you accept them at face value or don't. The idea that these would be explanations that would be, somehow workable or reasonable or explain away the situation. It's one thing for a person to give an account that, if believed, makes sense, explains things. But we're talking about Mr. Mensah's explanation, which is alleged to have been that he was going to wear size 5 girl sneakers, which officer, I took it from point of view that it's pretty obvious that Mr. Mensah wasn't going to be able to fit those sneakers.
I'm sorry, Mr. Rogers. It cut out for a few minutes. You started with
Okay. What's the last thing y'all heard?
size 5 sneaker.
Okay. What I was saying is that it was my understanding of the officer's testimony that it'd be rather apparent that Mr. Mensah wouldn't be able to fit those sneakers. And so my point is that for that to even be his explanation, regardless, without getting to if you actually believe that, for him to think that explanation would be sufficient to address the situation, I think goes to the idea that, a person's not operating from a place of competence. Additionally, if it was a sincere, intentional belief, that only further goes to that he was planning on actually wearing those sneakers. Another thing, the explanation about, for one, admitting to taking the ID to try to use it to purchase a firearm. It's the idea of a woman. Mr. Mensah does not currently present as a woman. There's no testimony that he was presenting as a woman that day. As Officer pointed, volunteered, I appreciated that. There's an obvious difference in complexion, not to mention presumably his sister, since we're calling her his sister, is a woman, with children. There's no reason to think that would work. So that's another, I think, I don't even know, red flag, whatever's beyond a red flag, that this person is not operating from a position of competence, that they think they're going to go present an ID for a woman of a lighter complexion to purchase a firearm. And again, to give that explanation to an officer, again, fresh out of Grady on a 1013. I would say that at this point, I don't know how we would ever get to a position of thinking that this man was operating rationally or competently at the time. And my main reason for stressing that is that, as it stands, he wouldn't have had the requisite appreciation for I would say almost anything that would be relevant to such a finding of competence. He didn't lie it away, didn't leave the scene. None of these things that would be consistent with somebody trying to get away with these things. And the whole enterprise was just is consistent with having just gotten out of Grady on the 1013, Judge. So for lack of competence, I would ask the court to dismiss it. Thank you.
All right, ADA, Thomas?
Your Honor, I understand that this gentleman had just been released from Grady, and I understand that he was in a situation of having to need at 1013, and I very much understand that that some of the things that he did would appear to us to be irrational. However, he was smart enough to get his mom's bank card. She's still not sure how he got it. He was smart enough to have her bank card code information and withdraw money for a specific purpose. He was rational enough to steal his sister's ID because he knew he needed a card ID as opposed to a paper ID to get a gun. That's the scariest part of all. I believe the ultimate goal in all of this was to get a gun. Now, his niece, I am assuming because she is his daughter, his sister's daughter, from my understanding of what the officer's testimony was and from my reading of the warrants, was a child. And perhaps he may have said that he was going to wear her shoes, but he got equal value because he was able to trade her shoes and his sister's purse for things that he wanted. Now, would I have made the same decisions had I been in his position? I don't think so. But he was rational enough and he was competent enough to make decisions, get money, get a bank card, take his mom's bank card, get the money, all in an attempt, presumably, to buy a weapon. That sounds kind of rational to me. I think that for the purposes of probable cause, we have sufficient evidence here presented by the officer for this case in its entirety to be bound over to the Superior Court.
All right, based upon the evidence presented, I do find that there is sufficient probable cause to bind this case over to the Superior Court of Clayton County. That's the order of the court. Of course,
Thank
the
you,
court
Your Honor.
then do a competency evaluation.
Officer Fender, thank you so much. Please go home and take care of you. Log off and take care of yourself, okay?
Thank you, 88 Thomas, Your Honor, Mr. Rogers. Thank you so much. You have a great day.
Have a good one. Feel better.
And Your Honor, if we can go back to Officer Tyson's case, Nicholas Williams, I believe that's also Mr. Rogers' case. I'm not sure if I have anything in Ms. Boulware's left. Let me look.
Okay, does anybody need to take a little quick restroom break? Yes, okay, let's take 5.
Yes.
Okay. Deputy, we're gonna take 5.